there's a Marshall report that's been going around, and Lynn Wood is in support of it, and a lot of people are asking me questions like, is this real or is this bunk, that Trump might be moving forward to operate, as Trump said, in a different form, and some are saying under a new republic, or actually revisiting the early republic. But since you and I have met together, Mark, we found out that there was in existence a republic, and that over time, due to bankruptcies, the United States of America lost its sovereignty because of the financial aspects. So I want to go through and I want to review what the evidences are, because there's so many people asking me questions, and I'd rather just kind of catalog all the data, do it once and for all, and then people can refer to this audio and do research from here. Obviously, I don't know everything. I'm just somebody who's been around studying this stuff since 2009, specifically in the private area of law, 2001, and the public side of law, because of my experiences with the Catholic Church, which you're very familiar with.
Yep.
So what I'd like to do is read some things into the record with you, and of course, everything I'm saying here, there is no legal advice being offered. There is no tax advice. There is no medical advice. This is for entertainment and education purposes only. And so I'm just sharing this as a matter of my research, connecting the dots once again in regards to some topics that are pretty serious. People are asking, and I'm just going to have to share what I know, and maybe others can pick up from where I leave off and go with it into a deeper direction. So first, I want to bring up a letter, and I don't know if this has come to your attention yet, but there was a letter issued in support of a case, and I will read the number off for those who have pacer.gov. They can go look it up. So this here is a case that was, let's see, in regards to Roger Allen Moore / Raj, R-A-A-J, MXM Moore Raphael. This is issued by the White House, May 4th, 2020, signed by Donald Trump on the left-hand side, which is fascinating, because apparently he does know creditor debtor law, because he's signing on the debtor side of the ledger, and on this letter. So basically, I'm going to read this to you. Case number 20-40375-KKS, filed 10/14/20. Okay, May 4th, 2020, regarding U.S. federal person, open quote, Roger Allen Moore / RAAJ, this is all in capital letters here, AMEXEM Moore, MOOR, space Rafa, space L, close quote, taxpayer identification, decedent social security number, 126-56-2303, and this is how you can go into pacer.gov and actually look up the case number. You can do a search also based on the social. This letter is in attention to that person. This is from Donald J. Trump. Note, see United States Department of the Treasury, Internal Revenue Service Forms 2848, Power of Attorney, and Declaration of Representative and 56 Notice of Fiduciary Agent sent December 1st, 2019 via United States Postal Service certified mail number 7016-0910-0002-3020-3644 to whomever United States business entity this may concern, who commercially operates on United States public, which is underlined, public, markets and accepts and or exchanges in United States currency while providing goods and or services to U.S. customers, consumers in everyday commerce. The above-mentioned U.S. federal public, word public is underlined, person has a prepaid, non-obligatory commercial debt obligation arrangement with the United States in relation to 12 U.S. Code, subsection 95A, regulation of transactions in foreign exchange of gold and silver, property transfers, vested interest, enforcement and penalties, Part 2, and other public policy on U.S. debt. Your business entity is federally bound to United States and to U.S. public, again, is underlined, debt obligations by way of your Internal Revenue Service Employer Identification Number, the IRS being under the U.S. Department of the Treasury, and your Federal Reserve Business Bank account. Your business is hereby ordered to itemize whatever and however many commercial products and or services in which the above U.S. federal public person wishes to commercially acquire, adjust the bottom line total cost amount to zero, and release the items. Provide a receipt to the above U.S. federal person by way of its duly authorized representative. Now, this isn't lowercase, upper lowercase, proper name, style written, RAAJ Raphael dash sui juris de jure, improper person, and retain the record of the transaction to settle with your federal tax obligations, with Internal Revenue Service as the entire overall transaction is only a commercial accounting matter of what the bankrupt United States owes its true creditors, which is the American people, in direct relation to the borrowed gold and National Banking Emergency Act of 1933. All commercial public debt obligations while transacting all business within the United States commercial markets belong to the United States, as the United States is the true obligor in each and every U.S. commercial transaction. Now, this entire sentence here after is also underlined and bolded. Any willful dishonoring and or non-settlement of United States commercial public debt obligational matters by any duly bound commercial business entity within the United States will result in federal prosecution to the fullest extent possible. Sincerely, Donald J. Trump, President, Chief Executive Officer of the United States. Now, this letter is saying a lot. Number one, Trump knows about the Emergency Banking Relief Act of 1933. He knows that it was amended several times since, but he also knows that that Emergency Banking Relief Act was actually the Trading with the Enemy Act. And the Trading with the Enemy Act in 1917 was officially written in order to define who the enemies are of the United States at that time. It also is under the older statutes. So, bottom line is, after the First World War, 1917 was defining that there were enemies outside the United States that the United States government had to be cognizant of. And then when it was amended in 1933, the wording changed from enemies without the United States to enemies within the United States. And Dr. Eugene Schroeder goes into this in tremendous detail. I was teaching this class several years ago, way back, and I think it was 2010 or 11. And I knew of Eric Phelps. I've known of him since 2007. And I didn't have the time to go through all of the history. And I knew if I could just get him on board and see if he could research this, he could go into greater depth and deconstruct exactly what happened in this country. The only reason I bothered to ask was because I lost a court case, Commonwealth of Massachusetts, of which I was a witness, versus Joseph Chu Kong, a monk at St. Joseph's Abbey in Spencer, Massachusetts. And so when I saw what took place in that courtroom and I gathered the evidence afterwards, this was not me against this priest. It was the state of Massachusetts, the Commonwealth, of which I was a witness for because I was a corporate fiction at that time. I didn't know anything. That's why I took it all personally. And then I find out that Sarah Chambers writes me when I went up against the Board of Overseers, and I said, wait a minute, this case was botched. I had evidence to back that up. That's on www.clergyvictim.com. In the articles section, you can find the grievance against Attorney Murata, and you'll find that essentially there is evidence that this case against a priest who sexually assaulted me was botched. So why would this happen? This happened way back in 2001, before all the big cases hit in 2002 in the Boston Globe and so forth. Why did this happen? So I started to ask the questions. And my story is told, as you know, Mark, you saw me do this on the International Tribunal for Natural Justice. Just type in Keri Bernor, and you'll be able to get all the information as far as the case goes. But this is where I started to ask my questions and found out that somehow, some way, a foreign power was what was ruling the courts. And that foreign power, as years went on, I found out through the study of law, was that we used to have English law. We used to be under the colonies, under Great Britain. And everything started to change as our history developed. So in 1776, we had the Revolutionary War. And as time moved on, slowly but surely, this is where Eric Phelps perfects this. He actually takes the entire history of what happened from the origins in the United States, the original republic, the United States with a small u, and he develops that history and shows that the original intention was that we were originally free, and now we have been enslaved. And how does this all make sense? So now I'm going to start going through a little bit of the history. The bottom line to reading this letter, signed by Donald Trump, is to illustrate that he is aware of two, I don't want to say governments. I would say one is a jurisdiction and the other is a government. In 1868 is where Eric believes and has the evidence to say that, okay, there's something happening with regards to the Jesuits taking over this country. So I'm going to start just going very basically into some of the research that I'm doing, because the Marshall Report that came out stipulated that in 1871, that's when things started to change, that the Constitution started to change, that the original documents were basically statutized, turned into something more of a corporate nature. And so the original laws that were governing at the time of the early beginnings was equity. In the legal field, we've heard of equity. You've got Gibson suits in Chancery. You've got a lot of literature out there. But when you boil it all down, civil law came, and it came at a time, and it started to take precedence over this equity. Now, in my experience, as you know, Mark, I've discovered that there is, in fact, an equity jurisdiction that still exists in the courts in the United States. But this is not something that is readily advertised and is only accessible to those who know how to lay down that jurisdiction. In their paperwork or through letters into chambers with the judge, there are two systems that are going at the same time. And so I'm going to go through a little bit of just some research to help us make sense of some of this. And then I want to show the bottom line, how this is affecting us. Because it's so much information, as always, I think what I want to do is just put the history on hold for a second, and I want to bring this to bear. I want to show how this is affecting us in our daily lives. This is actually very serious. This is not funny, but I'm in my own way, sharing a little bit of shock over this. And I've known about this. And this is something that, because Donald Trump has issued this letter and it doesn't say confidential, private, or special, or eyes only, or for official use only, I feel comfortable now coming out with this, even though it is rather sensitive. Here's how this affects us. So, Mark, let me ask you the question. Have you ever gone to get a passport, a U.S. passport before?
Yes.
Okay. On page 4. This is very disturbing. On page 4, it says the following. This is page 4 of 4 on the instructions. You have a DS-82 form, which is a blue form, and you have a DS-11 form. So the situation is you have the first page, and none of us just stops and reads the entire thing. People are just so excited they're getting ready to go on a big trip or something. They look at it, they say U.S. passport renewal application for eligible individuals, and you just fill in the blanks as a normal person would, right? You go down to CVS, you get yourself a picture of your passport photo, and you just do the documents, you write it all out, and you put in your trip where you're headed out to, and you're all excited, and you didn't realize that there was something very serious on page 404. Here we go, under acts or conditions, and anyone can go to Department of State and download this form for yourself. Page 404, either way, whether it's the 82 or the 11 form, it will still say the same thing. Okay, this is a brain twister. If any of the below mentioned acts or conditions have been performed by or applied to the applicant, here it is. The portion which applies should be lined out, and a supplementary explanatory statement under oath or affirmation by the applicant should be attached and made a part of this application.